We are Legally Sis. Welcome to our podcast.
The information provided in the show is for general informational purposes only and should not be construed as legal advice on any subject matter. No attorney-client relationship is created between you and Duran Duran-Schulze Law.
Hi! Welcome to Legally Sis. I'm Attorney Wen.
And I'm Attorney March. Welcome to our podcast.
How are you?
I'm good. Thank you for asking. In this episode, we will be discussing about titles. So we'll try to cover Reconstitution of Title, Reissuance of Title, removal of encumbrance, and correction of title. So, Attorney Wendy. Recently, Attorney Wendy, we had a client that approached us. She said she wanted to sell her condominium. However, she couldn't find her certificate of condominium title.
You mean the original?
Her original, correct. So what are her options?
Okay, in that situation, she has the remedy of filing for the reissuance of the owner's duplicate of title.
Reissuance. Some are confused between a reconstitution and reissuance. Could you please distinguish the two?
Okay, so there's actually a distinction between the two. Reissuance refers to whenever your owner's duplicate of title has been lost, stolen, or destroyed. The title is in your possession. But for reconstitution, it is the original title that is in the possession of the registry of deeds that has been lost or destroyed.
So definitely in this situation that the client approached us about, since she lost her title, it would be a reissuance of title.
That's correct.
Okay, what are the first steps that she needs to do?
The first thing that she needs to do is to execute an affidavit of loss, detailing there the description of the property that has been lost, and also the circumstances as to why the original's duplicate of title has been lost.
In the execution of the affidavit of loss, is it necessary that a lawyer already would have to help?
Well, it is recommended that you secure the guidance of a lawyer in order to assist you in preparing the affidavit of loss. So at least you know if everything has been stated correctly there.
After the execution of the affidavit of loss, what's next?
And you have to have your affidavit of loss notarized.
Mm-hmm.
And if you're in abroad, you have to have it apostilled or legalized.
And then you keep it?
No, of course, no. The next thing you do is go to the registry of deeds having jurisdiction over the property where it is located and then have it registered.
So why is it necessary that the affidavit of loss be registered with the registry of deeds?
It is actually mandated by the law that you need to notify the registry of deeds whenever there is a loss or destruction of your original's duplicate of title.
Do you need the certified true copy of that encumbrance?
That is actually one of the requirements that you need whenever you file for a petition for the reissuance of your original's duplicate of title before the court.
Okay, let's go to the requirements. What do the person need to present so that the reissuance of title will become successful?
Okay. First, you have to have your petition, which has been drafted by a lawyer, of course. And then your attachment or your supporting documents will be your certified true copy of the title, wherein the encumbrance of your affidavit of loss has already been annotated at the back of your title. The next thing is the tax declaration, if you have one, supporting documents with respect to the payment of the real estate taxes.
So it's necessary that the real property taxes are paid?
Well, it is actually encouraged that you make it a supporting documents for your title.
Okay, so you need the certified true copy of the annotation that the title has been lost.
Yes.
Certified true copy of your tax declaration. And what else?
Payment of your real estate taxes, the local assessment or certification from the local assessment. Declaring your property has been assessed for real estate taxes.
Who can file?
Okay, who can file? It's the owner, of course, of the title that has been lost, stolen, or destroyed. and any other parties who have interest over that property, such as the lenders, co-owners of the lot.
Does it require publication?
Yes, actually, before you have a hearing, or before the court will actually accept your evidence, the court will require you to have the petition as well as the initial hearing date of your case be published in a newspaper of general circulation.
How much should the client prepare?
Well, excluding the professional fee for the lawyers, the client should prepare for the filing fees,
Which is dependent on
the assessed value of the property.
Mhm.
The client should also need to set aside the fees for the newspaper.
that is the newspaper of that is the publication with the newspaper.
Yes, that's a publication.
So what do we expect during the proceeding?
Okay, for the initial hearing, the court will require you to have a jurisdictional hearing. So what is a jurisdictional hearing? This is the stage wherein the court will verify whether it has jurisdiction over your case and whether it can entertain your case.
What are the possible complications? For example, someone would oppose the reissuance of your title.
Yes, that's one of the complications. Well, mostly common complications is that there is an opposition regarding the issuance of your title, especially say that the title is not really lost at all or destroyed, but it's actually in possession of a third party, say a lender or a co-owner.
That is the reason why there is a necessity of publication.
Yes,
So
in
it-
order to determine and to appraise the third parties or the whole world in general that there is a petition for a reissuance of the new title.
So let's talk about opposition. There can be an instance wherein the person can try to ask for the reissuance of title, telling the court that he lost the title, but the truth and in fact, it was used as a collateral to another person.
Yeah, that actually happens, But if in case the court will issue a new title and later on it was discovered that the title is actually not lost or stolen but in the possession of a third party, say the lender, the issuance of the new title will be invalidated.
Okay. Let's talk about the situation wherein you bought the property, but the seller does not want to turn over the original title.
Okay.
What are your options?
Well, the buyer has the remedy of compelling the seller to produce and to deliver to him the original duplicate title or the original title to him.
And what if he doesn't?
If he doesn't, the court can actually issue a new title and then canceling the old one, issuing in favor of the buyer.
Okay, let's talk about reconstitution of title. You mentioned that this happens when there is a situation that the registry of deeds lost its copy of title.
Yes.
For the benefit of our listeners, there are two types of loss. The first one would be the owner lost it, and then the second one would be the registry of deeds lost it. For example, the registry of deeds suffered from its building suffered from fire, or there is a flood destroying the the properties or the titles in their possession. Why is it important to reconstitute the title?
Well, it's important to reconstitute the title in order for the registry of deeds to have a copy of your title. So,
Yeah, for example, I want to sell my property.
yes.
I have the original title, but when I sell it, the buyer will not be able to cancel my title and a new one be issued to him because,
There's no copy of the title with the registry of deeds.
yes, and it is important because the registry of deeds would need to confirm if that title really exists. And they would have to check their records if they have a duplicate or a copy of that title in their possession. And if they lost it, then you have to hire a lawyer to have it reconstituted.
Yeah, because in the process of reconstitution or judicial reconstitution, you need to go to the court or the regional trial court having jurisdiction where the property is located. Ask for the reconstitution of the title that has been lost in the registry of deeds.
Let's talk about correction of title.
Okay.
We had a situation wherein one client is married to a foreigner, and foreigners usually do not use their maiden name. Unfortunately, in the certificate of title of their condominium, the middle name of her husband was dropped. And now they're wanting to sell the property, but they're having difficulty because the IDs and the name in the title do not match. So what's the option?
Okay. The remedy is actually to file for the correction of the title. You need to go to the regional trial court having jurisdiction over where the property is located and ask for the court to have the title corrected.
So an affidavit of one and the same person will not work.
It does not suffice at all.
What if there is an error in the name? For example, it was written as E instead of an I.
Same thing. You need to ask for the court's order regarding for the correction of your title.
Okay, remember we discussed about correction of name. So what if you bought the property prior to correcting your name? So the name in the title is incorrect, and then you finally had your name corrected. What happens now?
Same thing. You need to ask for the intervention of the court in order for the title to be corrected.
So the takeaway would be sell it before you correct it. Okay, what about you have an encumbrance in your property? What is an encumbrance?
So, an encumbrance is a legal thing that burdens the property.
In short, it's not a clean title.
Yes.
So what are the examples of encumbrances?
Okay. Examples are those titles that have been reconstituted, the titles that are issued, that there is a settlement by the heirs on the estate of the deceased person, and those encumbrances by reason of the property being mortgaged to a lender.
So there is the Rule 74. This happens when someone dies and the property is transmitted to the heirs. There would be a Rule 74 annotation in the title. And then the other one is when you reconstitute or the title has been reissued to you, there would be a notation also at the back of your title that would say it has been reconstituted or it has been reissued.
Section 7 of RA 26.
Okay. There would be instances like voluntary encumbrances. For example, you took a loan, right? A real property mortgage. Or how about guardianship?
Or involuntary dealings as well.
Involuntary dealings or easement or even lease. Let's talk about having these encumbrances removed. So if it's just a simple Rule 74 wherein your parents, for example, died and then these property are now transmitted to the heirs, how are you going to remove the Rule 74 in the title?
You have to file for the petition for the removal of that encumbrance and bring it to the registry of deeds having jurisdiction over the property.
Yeah, you're correct. These usually take about 3 weeks to maybe 6 weeks from the time that you have requested for that Rule 74 to be removed. But do note that you can only file that petition with the Registry of Deeds 2 years following the annotation.
The 2-year period is actually for the heirs or any other third parties who has interest over their property to go after for the nullification of the settlement.
Why do you think the law made the 2-year period rule? Maybe because it will allow the creditors to go after the property of the estate.
Well, not only the creditors, but also the heirs or the other heirs who might be excluded from the settlement of the estate.
Yeah, it happens all the time. For example, there's an extrajudicial settlement of estate stating that there are only 2 children, but the truth and in fact there were 4.
Yep. That
Right.
happens.
So the encumbrance stated in the title would actually serve as a notice to the public that an extrajudicial settlement of estate has been done. How about mortgage? Once you fully paid your mortgage, can you have that encumbrance removed?
Yes, you can actually remove that also. But before you have it removed, make sure that the cancellation of the mortgage has been registered with the Registry of Deeds. So that's a separate step or a prior step before taking the cancellation of your encumbrance.
We talked about the people that can file for the reconstitution or the reissuance of the title. You mentioned that this has to be done by the owner or those that have interest on the title. So, for example, there are multiple co-owners. Can one petition and without the consent of the others?
Yes, you can actually petition for the reissuance of a lost or destroyed title because this will benefit the other co-owners. And the fact is, the title will be issued wherein the other names of the co-owners will be stated there.
Okay, that's it. Thank you for listening. Bye.